Welcome, welcome, welcome to the party with DJ Racist Cult Leader. DJ Racist, DJ Cult Leader, DJ Racist, DJ Cult Leader, DJ Racist, DJ Cult Leader, DJ Racist, DJ Cult Leader. I just wanna sue somebody. I just wanna sue somebody. That's what we're gonna do, yeah. Sue somebody. I just want to 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 sue somebody for negotiable instruments. In the house, pickles in the house, little bitty pickles in the house, gonna dance for you, yeah. Little bitty pickles in a jar, 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 pickles in a jar. Strobe light, strobe light, strobe light, strobe light, strobe light, strobe light, strobe light. Whoa! Bro. Welcome, everybody. Welcome to Glendale Round 3 with your host, Racist Cult Leader. Welcome. Oh, man, I thought you guys would love that. Let me turn this music off. Too good, dude. I wanted to do like an epic fucking intro on this video because I am so fucking excited, dude. This is the way that we're starting 2026. I've got studio lights now. So I have a light here and I have a light here. We may go through some adjustments on these lights. You can see it creates a bit of a shadow over here and stuff, but it's way easier on me. I used to have this big, huge thing right in my face. And you guys would always notice me going like this. I had to look around it to read everything. Now everything's real clear. I can see my screen really easily. The two lights are over here. Super badass, all getting ready for 3.0. This recording thing is fantastic. I always can see where the camera is. Pretty awesome. I'm pretty happy overall, I got to tell you guys. So, with that said, here we are with Glendale Round 3. They finally turned off my power. Thank Christ. Been waiting for it. Bro, I swear to God, it was the funniest fucking thing. I was in bed, and I woke up. Like, no joke, I have a fan above my bed. And I swear to God, as soon as the power cut, and as soon as the fridge went off, and as soon as the fans of the fan upstairs, the fan blade started to slow down, I woke up like this, bro. Like something out of a movie. Like I was like, what? Because I have a sound machine that I sleep with too. But I'm telling you, it was like before the blades of the fan had even barely started slowing down, my eyes were wide awake, bro. I was like, And I was like, the power's off. And I was like, is this it? I was so excited, dude. It's so crazy, right? Because I've been pumping myself up for this for so long. Like, I was so scared for so long, and I had to like pump myself up, like, well, I don't know how else I'm going to be able to put this together. I have to get damages. How else am I going to get fucking damages? Well, I got to let them turn off my power. And at first it's like, fuck, you're not going to have power. But then I was just like, you know what? What else are you going to do, bro? Like, you don't have any other option. You got to move forward. You got to move the ball down the field. All right, yeah, okay. What's the worst that can happen? Could I get the power turned on in 3 days, 4 days? I didn't know how it worked. I didn't really even know anyone who had really had their power turned off, so I didn't really even know who to ask. And I just thought to myself, you know what? I'm not that much of a fucking pussy where I can't go without power for however long. It's not a big fucking deal. But then I started to get kind of excited about it. And I was like, well, what if like I do more cool stuff, or what if I start reading, or what if it's like it'll get me out of the house, or I don't know. I just started thinking about all this kind of random cool shit. Like, well, what if it gets me out of the house? What if I can do other cool shit? What if it kind of motivates me to do other shit? I don't know, whatever. Maybe, I don't know, whatever. And I started to get kind of pumped up about it. And it took them 3-4 months. And you'll see all the documents, and we're going to go through everything on this video, right? But when it happened, I've had my power turned off before, but it was like a zip code wide or city wide or whatever, right? So the first thing I did was I jumped out of bed, put my pants on, put my shirt on, and I checked my phone, and I said, is this a power outage? And there's no text. There's usually a mass text, right? So I said, all right, I got to go in the hallway. I got to go in the hallway and snoop around and see if it's just my apartment only, right? So I go in the hallway, and I'm snooping around, and I'm like listening in people's apartments and stuff, and I don't hear anything weird. No one's coming out of their apartment. The lights are on in the hallway. The lights are on everywhere else, and that's when I realized, I was like, that's it, boy. We got it. We got it. And I already had like a really basic complaint already written, but I ended up like completely rewriting it and gutting it and doing a ton of like basically writing it from scratch. But been working on it nonstop since, when did it happen? The 13th, I think. So 10 days of all day, every day, total fucking obsession. The past few days have been mainly just like formatting and trying to get it formatted properly to get it accepted, which I'll talk about in the show here. But yeah, it's been fucking awesome. I'm super excited. This is, so like last year I did the writ of certiorari for the SBA case, and I did my book, which was like the next level for us in terms of, citizenship and, state citizenship and kind of how all that works. And negotiable instruments is something that you haven't really seen me talk too much about for quite some time, because I've kind of been on that writ of certiorari. Writ of certiorari was talking about, sovereign immunity, and it was talking about case removal from state to federal court. Those are the two big things that were brought up in the writ of certiorari. So a lot of research went on behind that, and then the book was all citizenship and history. So negotiable instruments is something I haven't touched too much on for a long time, and I know it's your guys' favorite subject. I'm well aware. I do love it. I do find it fascinating. It does get me giddy. There's no question about it. I think the citizenship stuff is more important. Not by like a lot, but I think just like objectively, like factually, it's more important. Because when all this is said and done and the Pickeltarians run the universe, all the negotiable instrument stuff is going to become irrelevant. The citizenship stuff is not. So the citizenship stuff is evergreen. The negotiable instrument stuff is just temporary. And by the looks of things, maybe very temporary. I don't know if you guys have seen the price of silver and stuff like that, but whew. Anyways, with that said, welcome. Welcome to Glendale Round 3. So if you remember, the last time I founded state court, Oh, God. I think it was the SBA case. I was trying to hit them with some stuff, and then they removed the case from state to federal court. It was a total botch job. I was handwriting all over everything, I was at the courthouse just handwriting all over. If you go back, you can still pull up all the documents. If you go to recap and you look at that first filing that the DOJ guy filed in, he filed in my original complaint from the state case. I think it's attachment 1 on the first docket item, or attachment 2 or something. You can actually see I had handwritten stuff on the upper left because they wanted something from there, and it was just a mess. And I didn't really understand like procedure, and I didn't really understand what was going on. So with this one, I went through all of the procedural aspects of how to file something, and you can see it's in Burbank. So whenever there's a hearing or anything, I'll let you guys know. And if anybody wants to come and see me in person live in the Burbank courthouse, that's totally fine, as long as you guys follow the rules and aren't disruptive and creating chaos. I have no problem with that. So I will keep you guys updated on any hearings with this case. Okay. It's a commercial case. It's involving the commercial code. So I just did without prejudice, just as a safety procedure. Anything involving commerce, I don't see why I wouldn't do it. You see I signed as the owner because the plaintiff is the sole prop. Just like I always do. That shouldn't be new to you, right? Here's the civil cover sheet addendum. You can look at this if you want. Not very exciting. And then here's the complaint. First thing, people are going to say, oh, you use in pro per. Oh, wow. Okay, it's totally irrelevant. It means absolutely fucking nothing. So California just tends to use in pro per rather than pro se. Totally irrelevant. First off, it's irrelevant because I don't think pro se and pro per really make any difference at all anyways, but it's irrelevant because the sole prop is the fucking plaintiff. I don't know how many times I got to tell you guys this, because I know some dumb fuck's going to go, pro per, oh my God, and they're going to freak out. And it's like, bro, did you just arrive to the sovereignty space like today? Like, what the hell is going on with these people, bro? If you've been in the sovereignty space for more than 6 minutes, and you're fucking talking about it pro per versus pro se, like, that's pathetic. Like, you are pathetic. Like, fuck you. Literally. Like, what the fuck are you doing? Okay. So, you can see, it looks a little weird, right? There's a reason for that. So, when the case was disapproved, I went through, there was a bunch of different, it said on there, like, the complaint does not match the procedural code of California Civil Procedure 1.4 whatever and to 1. Whatever. So I went through every single point of that whole section of the code, which was 25 different sections. Most of them are just a sentence or two. And I did every single thing. So I went to let me remember what I did. It was California Rules of Court 1.200 maybe. I don't remember where it was. Let me table of contents. I bet you I can find it in the table of contents. Construction of rules and standards. Let's go back to table of contents. Let me just take a look here. Yeah, one. Let's see here. Let me pause. I'm going to pause the video for just a second and see if I can find that thing. Yeah, so I found it. It's CRC Rule 2.100. So she said, this is what you didn't do, right? So what I did was I went through each of these rules. One-sided paper. Papers that are not filed. So I filed electronically, so this one didn't matter. No, when I keep saying 2026 is the year of procedure, this is what I'm talking about, guys. And I know it's not sexy. I know it's not filled with glory. I know it's not filled with dancing King Pickles talking about how they're DJ racist cult leader with potpourri splashing through the air with music. I know it's not Rockstar. And that's why I've never liked it. But we have to do it. We have to do it. I'm telling you, I've tried everything. I'm the guy. I'm the guy, man. You've been watching me smash my skull against the wall for a long time now, and I'm telling you, finally, it ain't going to happen. We have to learn this stuff, right? So font size, what do we have here? Font size not smaller than 12 points. So you'll see everything in there is 12 points that I did. It has to be Courier, Times New Roman, or Arial. Okay, I did that. I did Times New Roman. But this is what I did. I just went through every single one. Font color is okay, blue or blue-black. And margins. So this is the one here. You'll see must be at least 1 inch from the left edge and the right margin at least half an inch from the right edge. So when you see, so it's got the bigger margin on the left and the smaller margin on the right. I just did that per exactly what it says, dude. That's why I did this. They wanted these numbers on here. The lines need to be numbered as part. I'm not going to keep going through all those procedural points. But just to give you an idea, for those of you who are maybe new to some of this stuff, that's all I did. I just went through every single one. I just followed the instructions in every single little point. You saw we went through 5, 6, 7 of them in just a couple minutes. It took me, maybe 40 minutes to go through here and to reformat everything. And then you have to have the page number at the bottom with a line, and then you have to have the name of the document underneath the line. So all of this is even the in pro per. I actually looked up a template. I typed in pleading paper template, and I got this. I'll show it to you guys. Pleading paper template for Google Docs, straight from the Sacramento Public Library. And you can see here, it says your name, comma, in pro per. It tells you to use the in pro per. So I looked it up on AI, and it turns out it's very common in California to not use pro se, but to use in pro per, but there's no real other information about it. So I just said, all right, fine, I don't care. It makes no difference to me. Sole props the plaintiff. What do I give a shit? Pro per, pro se, fucktard. I don't care. Any of the above is fine with me. So we just have a very simple, just you guys have already seen this a million times, sole proprietorship, Brandon Joe Williams, represented by owner Brandon Joe Williams, hereinafter plaintiff pro per, jurisdiction and venue. You'll see some procedural stuff here, some California Code of Civil Procedure stuff in terms of that. And then additional jurisdiction is available using the Public Utilities Code 2106. Venue, because it gave rise to this claim, occurred in Los Angeles County. So you guys will be talking about this. Brandon Joe Williams is a sole proprietorship and resident of Glendale, California. Well, yeah, of course. I don't know who would be shocked by this. So the sole proprietorship is born in the District of Columbia. It's a 14th Amendment U.S. citizen. Its citizenship is with the District of Columbia. When it's in a state, it's a resident of that state. So, yes, the sole proprietorship is always a resident in a state. And one of the clearest places you can see that at, actually, is 26 U.S.C. 7701 subsection A39, which I have talked about a lot recently. Because this changed everything. I had a huge, I don't remember all the things that I changed, but I changed so many things from this, right? If any citizen or resident of the United States does not reside in and is not found in any United States judicial district, such citizen or resident shall be treated as residing in the District of Columbia for purposes of any provision of this title relating to jurisdiction of courts or enforcement of summons. So what does that mean? Any foreigners, residents, or any U.S. citizens, which would be any citizens that have rights and obligations under the 14th Amendment, because rights and obligations are tied together, they're basically, we don't give a fuck where they are. They're always in the District of Columbia. Well, yeah, of course, right? Since the sole proprietorship was born in the District of Columbia, this applies. So it's resident. The sole proprietorship is a resident or foreigner in a state. But when it comes to anything involving anything from the IRS, involving anything from the Department of State, involving any federal organization, the sole prop is always just in the District of Columbia. They treat it like it's just in the District of Columbia, which is very fascinating, because where does this come from? Where do you see this in Title 4? You see it in 4 U.S.C. 72. All offices attached to the seat of government shall be exercised in the District of Columbia and not elsewhere, except as otherwise expressly provided by law. Interesting. Offices attached to the seat of government. Very interesting. Very interesting. Okay, check this out. Back to 26 U.S.C. 7701. Let's go to the definition of a trade or business. The term trade or business includes the performance of the functions of a public office. Interesting. So when they say trade or business in the United States, they're saying U.S. citizens or residents, which would fall under 4 U.S.C. 72, are involved in a trade or business, public office. Office is attached to the seat of government. And then if you go to United States and state in subsection 9 and 10, you will see that it says the District of Columbia and the District of Columbia. We can show you that real quick. The term United States, when used in a geographical sense, includes only the states and the District of Columbia. And what's the definition of states? The term state shall be construed to include the District of Columbia. So the term District of Columbia, when used in a geographical sense, includes only District of Columbia and the District of Columbia. That's what it is, right? So so all your tax forms are trade or business in the United States. It would be public office in the District of Columbia is how you'd translate that. And it's just, this is the occult. We are looking at the occult. I think I've said that a couple times before, but not very common that I say that. This is the occult. We are looking at the occult. This is full-blown occult study at this point. I mean, so people will tell you, oh no, but the word includes blah, 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 blah. And you'll find the definition here in 26 U.S.C. I don't want to get off on too much of a tangent, but I haven't talked to you guys much about some of this stuff. They have it here defined. The terms includes and including, when used in a definition contained in this title, shall not be deemed to exclude other things otherwise within the meaning of the term defined. So it's just kind of funny that they have that here. Includes the performance of functions of a public office. But the problem is that the definition of the word definition means limits of meaning. Limits or boundaries of meaning. So if they use that on you, then your response would be, well, then by definition, this isn't a definition, because it's just open-ended and you can just plug anything you want into it. That's the first thing you could say. The better thing you can say is go to 26 U.S.C. 162, trade or business expenses, scroll down this extremely long page, and you will find that every single thing listed on this entire monstrous page has to do with public office. So what I would do is you create a presumption under Federal Rule of Evidence 301, and you say, look, I'm looking around and I'm finding all this stuff. It all has to do with public office, public office, public office. As far as I'm concerned, because of what I'm seeing in 26 U.S.C. 162, I'm going to create a rebuttable presumption, which shifts the burden of evidence back over to them, And it says, hey, if there are other things outside of public office that would fall under a trade or business, please provide evidence to support that, because 26 USC 162 does not support that. And then, I mean, unless they can produce something, I've never seen anything personally. So good luck. You'll need it for that one. That's how I would handle that situation, right? Totally going off on a tangent here. But anyways, I'm explaining all of that because you guys are going to freak out about this. I didn't say anything. There's no information on here about me at all. It says owner a bunch of times all over the place, but that's it. There's no information about me. It's not relevant. And that's something I've fucked up a lot in the past. Oh, go on and on and on about who I am and what I am, and I'm a state citizen, and I'm white, and all this, I'm not a Negro, and all this stuff. But the thing is it's really not relevant at all. In fact, if you were to actually look at the California Code of Civil Procedure 41010 and 395, they have to do with residency, right? But if I remember correctly, if you look at the Public Utilities Code 2106, you can actually gain jurisdiction without even having residency. So if I wanted to, I could just delete this top part, which would eliminate residency even needing to be talked about at all. And I could just have jurisdiction is available under PUC 2106, and then just delete and resident of Glendale, California, and just say Brandon Joe Williams is a sole prop and have even less information. I didn't want to do that because I wanted to have a couple different options for jurisdiction just in case anything happens, and I'm still kind of learning all that kind of stuff as we go. So because these 2 points involve residency, you have to put residency. And the sole prop is a resident in California. It's a foreigner of California. It's treated like it's in the District of Columbia forever. And that's exactly why the revocation of election can't possibly work. The U.S. citizen, the sole prop, cannot... There is no election to be treated as though it's in the District of Columbia. I was wrong about that, guys. And I've literally been saying this for over a year, since December of 2024, and people still, for whatever reason, don't know or aren't on board or whatever. It's like, dude, I'll keep repeating myself for 3, 4 months, 5 maybe, but a year, come on. Fuck you. You know what I mean? Go fuck yourself at that point. This shit's free. I'm not charging you to be here. My book costs a little something now if you want it, but it's optional. I mean, I don't consider it optional, but technically it's optional. There's tons and tons of stuff that you can consume without buying my book. I think that's dumb. I think it's probably the most important thing right now. Unless you're just looking for negotiable instruments. If you're just looking for negotiable instruments, this video is probably going to be the best thing on my whole fucking platform ever. Literally ever. So, besides maybe the 6-part series into UCC 3. But anyways, I'm not going to talk about that anymore. Background. A federal case was filed on the subject involving a different tender draft under case number blank. It was properly terminated for lack of diversity jurisdiction on January 27, 2025. The plaintiff improperly filed this case in federal court, but did not understand that at the time. I couldn't get any jurisdiction. I mean, if I tried again, would I be able to use one of those crazy other jurisdictions that most people have never heard of to try to get jurisdiction over a case like this? Maybe. But... The California Commercial Code is the UCC in law, so it actually makes more sense to be in state court. I should have never filed in federal court. It just kind of happened. It was a long time ago. I learned my lesson. I learned a lot about federal jurisdiction on that case. I'll tell you that. Just the amount that I learned about federal jurisdiction, the experiences that I got in the meet and confers with the attorney. Just those experiences alone was worth the $405 filing fee price of admission. I mean, I'm dead serious. Just those things alone, $405, it was worth it. So that's how I look at things, That's how I look at things. Nothing I do is a waste. It's always a learning. You're just paying, $405 to learn some really, really important tools. That's cheap. You can't even buy, an hour with somebody or something like that. So For me, it's the best money I've ever spent in my life, or currency or notes or whatever you want to call it, right? So point number 2. On June 18th, an entirely different action was begun in Pasadena Small Claims Court for another tender draft. This was under case number blank. The hearing on this subject took place on August 7, 2025. So real quick, at the very last second, I made a very small announcement on this, and I had about 10 people show up. I had an audience of about 10 people. But it was, I kept going back and forth, and do I really want people here for this? Like, I don't know. Do I, And then at the last second, I kind of shot it out, and then it was just like really sloppy. And like, so if you didn't really hear about that, don't be too shocked. This time around, with this case that we're looking at right now, oh boy, we're going to have the trumpeteers out there, my brother. We're going to be trumpet calling. We're going to be on the mountaintops. We're going to pack that courtroom. I mean, I'd like to pack it. My main concern is just making sure you guys follow the rules. You don't get rowdy. I don't know about how they're recording. If there's recording rules or whatever, we can maybe file in a request to have it recorded with some kind of more professional equipment. Maybe we can get someone like Vem Miller or something to come and record it with his expensive cameras, or if somebody else wants to. I don't know how all that works. I don't know what the recording rules are, so just keep all that in mind for this. Don't come in with meta glasses and screaming and, a microphone and get yourself in trouble. You can ask AI, Burbank Courthouse at this address, does it have, what are the rules in the court in room 225 or whatever it is? What is the rules here for recording in the courtroom? I don't know, whatever. Maybe it'll give you some, who knows? But I'm just saying, keep in mind, you can't just go in there and just be hog wild, and especially if there's going to be a million of you guys. It's not going to work. So if you could just be civil and you would like to come in and just watch quietly and respectfully and not destroy my ability to do this, then by all means, we're going to be inviting people to come, and I hope to have those dates for you, like weeks in advance, maybe even 4, 5, 6 weeks in advance. Okay. The plaintiff's owner was representing the plaintiff in person. The judge was quite impressed by the knowledge Brandon J. Williams had of the California Commercial Code, but ultimately dismissed the case due to lack of damages. Most of you guys are aware of that. Oh, real quick, this case is already up on Williams & Williams. You're just going to go to current and previous litigation. You're going to go down to case 13. There's very little information because the complaint has everything. And then right here, recap is for federal cases only, so there will not be a recap on this. This is going to be a shared Dropbox folder that I'm just going to manually stick each item in. I figured that's the easiest way to do it because California is awful. Los Angeles is awful. It'll cost you, to download this one item is going to cost you like fucking, dude, like $12. Like something absolutely out of this world. Okay. Like just completely insane pricing. So, and I think it's a total pain in the ass to navigate the site. So it's just going to destroy all interest in this case, especially since people are lazy and they're used to recap, which is really, really nice. So I think what I'll do is I'll put like discovery item, discovery requests, and then I'll put the date because 10 days after, I believe, I have to double check the rules, 10 days after delivery of the complaint, I can start to issue discovery requests, which I'm very, very excited about. It'll be my first time doing that. I will place those discovery requests in here. I know a lot of people have asked me about what questions would you ask and kind of all that stuff. This is my first time that I'm really, really, really going to be putting a lot of thought into that. All this weekend, I'll be thinking about it. All this week, I am going to be burning my skull, smoking cigars, thinking about discovery questions. That's it. It's just going to be a potpourri of fucking discovery questions, and it's going to be beautiful. So when I finally get that done, and I get that sent over. I will put a copy of it here. You'll see docket item 2 will probably be either the answer or motion to dismiss or whatever it is they file in. And I'll try my best to make it look like a docket, but it'll have other information too. It'll have other things too, like the discovery requests aren't going to be docket items because they're done. Discovery requests are private. So it'll just say like discovery request and have the date. And then I'll try to like have like a linear dated sequence on everything so you guys can see it. I think that's the best way to do it. That way you guys can access it super easily. It's free and it has all the info. This is my first time doing a state case like this. So if it needs to be adjusted or changed or something needs to happen with it, we'll just kind of figure that out as we go. Okay, I just wanted to let you know on that. So point number 8, Brown Joe Williams informed the defendant that he would not be activating additional litigation until real damages, for example, turning off the power, took place. This was in order to satisfy the requirements set forth by the Honorable Justice in the small claims case. This can be seen in writing under the, quote, response to a friendly reminder letter in Exhibit A. We'll get into the exhibits later. I think it'd be better if we get into it later. It's a little bit heavy on the UCC talk, so we'll just hold off on that till the end, okay? Brandon Joe Williams informed the defendant multiple times in writing and once verbally over the phone, speaking to in-house attorney Carl Arias, that each individual tendered instrument is a separate cause of action, that the cycle of tender, shut off, sue will continue until the defendant follows the law set forth in the California Commercial Code. This can be seen in the various mailings found in Exhibit A. Power to the apartment was turned off on... See, I didn't say power to the residence because it's a residence for the sole prop, but it's a domicile for me. So, and I just didn't want to get into all that. I'm just trying to like avoid it. It's not really relevant. So I just did apartment. If anyone's wondering, that's why I did it that way. Okay. Power to the apartment was turned off on January 13th, 2026 at around 10 a.m. and remained off until January 13th, 2026 at around 5 p.m. Brandon Joe Williams used a credit card to turn the power back on, even though all previous payments had already been satisfied in full, which that's going to get spicy. Wait until I show you that one. Oh, man. Plaintiff and his owner are fairly new litigants and plead the court to please not crush or heavily chastise in accordance with Haynes v. Kerner and Erickson versus Pardis. We've used these two a million times in like other filings and cases, so I just remembered those and I just figured it's not going to hurt to throw it in here. We are here in good faith, shown by the sheer length of time spent to solve this issue, combined with previous evidence of good customs, well-spoken pleadings, non-hostile communications, etc. The owner of the plaintiff will arrive in your court well-dressed and respectful. This is a promise, right? I dress really nice. You guys will be shocked because you guys will only see me in this shit, these black T-shirts. But I got custom suits, man. I got custom suits from Indochino. I mean, not a personal thing. They don't pay me to like say it, but it's fucking awesome. Like $600, totally custom suits, totally badass, amazing. You guys will see it when you see me in person. I actually have fashion sense. The ladies were pretty shocked last time they saw me in a suit. Presumptions. It is time. This is my first time really getting on the presumption train. So we have presumptions under 3 different sections. Presumptions under the California Commercial Code 1206 and the California Evidence Code 505 and 604. So the California Commercial Code, and by the way, all of this is like literally word for word straight out of the UCC. They never really change any of this stuff. It's just that you have to use the state version of the UCC. The UCC is a model code. And then that model code never really does, may get adjusted as it's placed into state law. In California, that state law is called the California Commercial Code. Ignore the COM. That's just something they use. I've not seen that written that way anywhere else. So I didn't use that. I used CCC. to abbreviate the California Commercial Code. So whenever this code creates a presumption with respect to a fact or provides that a fact is presumed, the trier of fact must find the existence of the fact unless and until evidence is introduced that supports a finding of its non-existence, which I know is a lot to think about, but it's even stronger than like a 301 presumption, because it literally it's a duty that the trier of fact must find true. So that's why I used it. I was like, damn, this is really powerful. And plus, when you go to appeals, you have to prove that there was abuse of discretion. 1206 creates the duty that they have to find these things true if they're said or presumed through the California Commercial Code. If they just, oh, you're crazy, fuck you, and they just kind of dismiss it, I think it's going to be my main argument for appeals is going to be 1206, because it's going to be that duty that they have to basically find these presumptions as true unless proven false, right? I think it's a huge improvement in this. It's one of the biggest changes that you're going to see in this over my previous complaints. I think it's a big deal because I think it gives me a lot more strength to move into appeals with a lot more strength. But we'll see, right? The municipal bills, hereafter referred to as drafts, found in Exhibit A are unconditional orders to pay as defined in the California Commercial Code 3104. So it's really simple. The California Commercial Code 3104 is just UCC 3-104. Do you see that? Like this one here, CCC section 1201. That would be UCC section 1-201. Sometimes they're a little different. Like you need to double check everything as you go, but I'm just showing you that's how simple it is most of the time, right? The drafts found in Exhibit A are negotiable instruments as defined in CCC 3104. The drafts found in Exhibit A are signed, quote unquote, when issued in accordance with the definition found at CCC 1201B37, which is not what you think it is. This is a huge misunderstanding that most people have. Signed. 1201, California Commercial Code 1201. And then 37, I have to move this thing. Let's see here. Not sure how to move that. Let's move me instead. 37. Sign means with present intent to authenticate or adopt a record, execute or adopt a tangible symbol, attach to or logically associate with the record an electronic symbol, sound, or process. So it's like any symbol that basically infers that they did it or that they accept it or whatever. So if we go down, this is page 12. If we go down to the unconditional order to pay, the draft, this symbol falls within the definition of signature or signed, a symbol indicating that they're approving some sort of written thing. They put their fucking, I'm sure this is probably trademarked or copywritten or whatever, so unless someone illegally used their symbol and created this unconditional order to pay, and I'm not aware of it, that's a signature. Any sort of symbol that indicates them, taking it on or whatever. So signed or signature is a really interesting definition when it comes to negotiable instruments. It's something that very few people are really aware of, right? So any sort of symbols, logos, symbols, technically speaking, a word is a series of symbols. So even text could be considered a symbol, right? Pretty interesting, right? So you also got to think sometimes you'll see that X that's sometimes pre-written on a lot of your signature slots. What is that? That's a symbol, right? Interesting, right? So why is that there? How is that there? How can that be considered that I'm signing? It's just an X. I didn't put that there. It's an interesting conversation. But it is signed. It's a signed draft. Where are we at here? Signed. The drafts in Exhibit A are unconditional in accordance with 3106, which is the section talking about conditional versus unconditional. Defendant is the drawer, which is the person ordering payment of the drafts in Exhibit A as defined in 3103. Plaintiff is the drawee, person being ordered to pay, and acceptor of the drafts in Exhibit A as defined in CCC 3103. Acceptance is defined in CCC 3409A. Defendant is the issuer of the drafts in Exhibit A as defined in 3105. Brandon Joe Williams, owner of the plaintiff, became the, quote, person entitled to enforce the drafts in Exhibit A as defined in CCC 3301. The endorsements of the drafts, once tendered by the owner of the plaintiff, endorser, back to the drawer, defendant, were both qualified in accordance with CCC 3415B, which is the without recourse, and blank in accordance with CCC 3205B, which is payable to bearer. So qualified is without recourse, and you can actually see that for yourself by pulling this up. Blank, payable to the bearer. Or if there's no payee at all and there's no payable to bearer and there's nothing, it automatically defaults to payable to bearer. Both of those would be blank endorsements, or another way of saying it is endorsed in blank. The note was endorsed in blank. The draft was endorsed in blank. That's the terminology. Blank endorsement, endorsed in blank, payable to bearer, all the same terminology. A lot of you guys should already know this. Some of you, we haven't talked about this in so long. You know, I'm doing kind of like a little micro refresher as we go, because we haven't really talked much about negotiable instruments for a long time. And I know you guys are interested. So I'm just kind of, the reason why I'm talking like this is just to give you guys a little micro refreshers as we go, because I've learned a lot too. I'm much more certain about a lot of this stuff, and I know more about it, and it's more filled out than it ever was in the past. So, when we get into 3.0, we're going to be doing tons of bills. We're going to pull the bill up. We're going to find the payee. We're going to find the drawer. We're going to find any signatures. We're going to find the drawee. We're going to circle. We're going to go crazy. I got IRS bills. I'm putting it all together. I got this whole folder. We're going to go through a whole shit ton of bills, and we're going to be locating everything. We're going to be going off a checklist. There's 3 items that an unconditional order to pay has to be in order to be considered a negotiable instrument. We're going to locate all 3 of those on every single fucking bill. We're going to locate the drawer, the drawee, the payee, everything. So I'm writing the outline. I got the lights. I got the software. Most of you guys like this software. I'd say it's like 90-something% of you guys. The frame rate's a little lower than how it was before, and it's a little bit kind of gay that it doesn't fill up the whole screen when I maximize. But the other benefits that you guys are going to get from this system, the first benefit is I'm not constantly fucking checking down here like a fucking idiot, like it's 2005. Trying to figure out what, you know, I'm pretty good at holding myself together even when I'm doing that, but it's like this gnawing horseshit thing in the back of my head all the time, and it's gone with this system. I mean, I can just fly like a fucking bird. And what I'm trying to do is I'm trying to bring back a lot of the fun and the goofiness and the energy of the 1.0, but with like the heavy ass information of the 2.0, you know, cleaned up and made better in the 3.0. So by having this, where I don't have to think about it and worry about it all the time, constantly what camera I'm on, I feel like it's going to help me bring back that 1.0 energy that I think is really going to be good for 3.0, because 2.0 was just all business, dude. Like, fuck you. all business. 1.0 was just literal fucking court jester retard shit. Okay. So what we're trying to do is we're trying to kind of mix those two things together, like ultra fucked through the roof, absolutely insane information. But we're going to mix in all the fun and the playfulness, and we're going to mix in the stories and the goofiness and the craziness and the singing and I'd like to see if we can do that. So I'm trying to kind of get there, not having this giant fucking thing in my face so I can actually see the screen. That helps a lot. Having these side lights, having this software helps a lot. You know, the other big benefit is it kicks out like the AI thing built into this software. It kicks out sections, and I copy all the sections and I paste them into the description in YouTube, and I don't know how or why or how it works. I copied it and pasted it into a thing, and it like makes these little cuts. There's like a line that across the video you can play, and you can like drag and scroll through the video. When you copy all of the stuff that AI gives me and you paste it, and I just learned this randomly, I didn't even know, into the video description, it auto cuts. So you can, and it pops up and says, you know, each section as you're going. It's pretty cool. So I know you guys kind of get lost with a lot of the videos because it's like, well, where was this and where was that and where was this? So another thing that this software helps me with is it's going to have cuts, and it's going to have timestamps, and it's going to be pretty cool. I think overall it's a big move in the right direction. I've tried contacting the company a couple times, try to get the frame rates up to 60 FPS. They're retarded. Surprise, surprise. So don't think it's going to happen. I think we're kind of stuck at 30. So the other thing is we're recording everything in 4K. So even though it looks kind of shitty when I pull up, it looks kind of like, what is this all about? Why is the camera like not as good and as clear as it used to be? But the overall picture, the whole screen and everything on it is actually a 4 times what it was before, because I used to shoot at 1080. And this is 4K. So you can actually take these videos, these new ones that I'm doing, and you can put them on a big-ass, huge fucking screen, and they're going to be like really, really crystal clear, the text and everything that I'm showing you. So I think that's cool too. If you guys, because I know people like to have like meetings or get-togethers or talks, you guys can put my videos in these new 4K. You can put it up on like a projector screen. You can get a projector and put it up on like a white wall and take up the whole wall. And it should come up really, really good, especially better than it was before. So overall, I think it's a really good upgrade, and I'm really excited about it. I think it's what we're going to use for the 3.0 course. So back to this. The provisions of CKC 3311B were met in the letters. This is pretty important, actually. California Commercial Code 3311B. Right. So, unless subdivision A applies, the claim is discharged if the person against whom the claim is asserted proves that the instrument or an accompanying written communication contained a conspicuous statement to the effect that the instrument was tendered as full satisfaction of the claim, which I did do in all my letters. Accompanying written communication containing a conspicuous statement. I did do that. So we're going to be talking about that in the lawsuit as well. The rules of dishonor for the accepted drafts in Exhibit A would fall under CKC 3502D, as these drafts were obviously accepted by the plaintiff and his owner, shown by the signature on the face of the instruments. The drawer does not have... This is where things get really fascinating. I started writing some of this stuff, and I was really patting myself on the back. This is the part where things get spicy. The drawer does not have the ability to selectively choose what kinds of notes or drafts he would like to accept, but is bound to accept all notes and drafts that fall within the definitions in CCC 3104 and would allow the defendant to become the holder as defined in CCC 1201A21. I've never seen anything, by the way, guys, ever that says that they can pick and choose what kind of notes or drafts they want to accept. I've never seen it, so it's good to talk about. Maybe they'll find something I've never seen. The defendant is legally obligated to accept any form of negotiable instrument presented as payment as described in CCC 3311, which is accord and satisfaction by use of instrument. All that a document or paper needs to have in order to legally classify as a negotiable instrument would be the 3 points found in CCC 3104 A1, A2, and A3, which is totally true. I'm just going to do the UCC version because I have this bar over here on the left that if I try to move it, it may freak out on me. I'm not going to move it. So here are the three things. Is payable to bearer or to order at the time it is issued. So let's take a look. Is this thing payable to bearer or to order at the time it is issued? I'm not 100% sure on what I'm about ready to say. So it's something we're going to need to talk about in this lawsuit, and it's also something that I'm still learning. I don't know everything, okay? But here is now you have the coupon at the bottom. Now, one of the only definition of coupon I've ever seen that ever made any sense was an interest payment, a detachable interest payment attached to a bond. So if that's true, which I'm not 100% sure it is, I haven't quite figured that out yet. So here we have the draft, and then we have an attached draft or something. It's basically two drafts here. The bottom draft is for the interest payment, and the upper draft is for the initial unconditional order to pay. That's theoretical. I don't really know. Exactly, and you're going to see some stuff that I found with this whole thing that's kind of weird involving the coupon. We're going to get into that too here later in this. But let's say this whole thing is one draft. It's not two pieces, and it's not detachable for whatever reason. I don't know. Obviously, that's not true, but let's just presume that for just a moment. Okay, so if that's true, then the drawer is City of Glendale. The drawee, the person being ordered to pay, is Brandon Joe Williams. And the payee is City of Glendale. Please make your check payable to City of Glendale. Now, this is one thing that I'll be getting into a lot in the 3.0 course, or we're at least going to cover it very thoroughly. If you look at the definition of bill of exchange, people always get confused. They're like, it has to have three parties. It has the drawer, the drawee, and the payee. But what I didn't realize for the longest time, and what I don't think a lot of you guys realize, is the drawer and the payee can be the same person. So if I say, I, Brandon Joe Williams, unconditionally ordered James Johnson to pay me at this date, then Brandon Joe Williams is the drawer, and Brandon Joe Williams is also the payee. So people get confused. They're like, oh, a bill of exchange has to have three parties. It has to have three parties, or it can be two parties, and the payee and the drawer are the same person. Very important, because people get confused, right? And what that means ultimately is that the word draft and the word bill of exchange is the same term. They mean the same thing. I was confused about that for a long time. Anyway, side note, right? But let's get back to this. We were on page 13, I believe. All that a document, is payable on demand or at a definite time If there's no payment information at all, then it's payable on demand by default. So that the default stuff, I think, is where a lot of people really fall down, especially new people to this information. If it doesn't say payable to bearer and it doesn't say payable to order, it automatically defaults to payable to bearer. If it doesn't have a time, or if it doesn't say payable on demand and it doesn't have a definite time, it automatically defaults to payable to on demand. These are huge, massive, gigantic black holes that people fall into, and they get confused and they're not sure. Maybe it is a negotiable instrument. No, you're fucking retarded. That's the issue. You are a fucking retard, and you need to keep reading and understanding that these things default. They default. So important. Every unconditional order to pay is either payable to bearer or order automatically, always. Even if there's absolutely no information on the draft at all whatsoever to define either way, because it defaults to payable to bearer. If it has no information as to payable on demand or at a definite time at all, makes no difference. It defaults to payable on demand. And then finally, does not state any other undertaking or instruction by the person promising to order payment to do any act in addition to the payment of money. And then there's some more information as to how a person entitled to enforce the instrument can deal with it or use it. Like those kinds of things are not considered conditional aspects. So really 1 and 2 are automatic. Even if there's no fucking information at all, you have a default clause on point number 1, payable to bearer. You have a default clause on point number 2, payable on demand. So really, guys, this is so huge because really the only thing you actually need to look for, I'm not kidding, is point number 3. That's it. That's so simple, isn't it? Oh my God, Brandon, that's actually... Holy fuck, I think maybe for the first time I actually understand it. Yeah, I understand. It took me a long time to understand this stuff. These defaults, the way things default if there's no information is so critical, so important. I'm telling you, basically that's it, bro. And number 3, you're not even going to see anything in subsection 1, 2, and 3. So literally, I am not fucking kidding when I tell you this. This is huge. If it's an order to pay, that's it. Any order to pay anywhere. And remember, payment and performance mean the same thing, so you can get even more vague. Any order to perform, that, just think of these highlighted words right here, and you're done. You're cooked. You're solid. Does not state any other undertaking or instruction by the person promising or ordering payment to do any act in addition to the payment of money. So I guess in this circumstance, we have to stick with the money part, the payment of money, because it specifically says that. So scratch what I just said on payment and performance, because this particular point would involve money only. So this is all you need. Everything else defaults. You don't need to worry about is number 1 there, is number 2 there. Just ignore all that. It's there. It's always there. Whether it's there or not, it's still there. This is the only thing you have to look for. Does not state any other undertaking or instruction by the person promising or ordering payment to do any act in addition to the payment of money. It's that simple, guys. We've gotten this that fucking simple. I am going to be going through UCC 1 and UCC 3 in the 3.0 course. We're going to skip UCC 2. I don't think it's very relevant. I think it's like sales and leases is UCC 2. I don't really care. I may review that and we'll see how things go. But I think we're just going to go through UCC 1 and then we're going to go through 3 again in 3.0. Definitely. So, but 3.0 may not come for a while. We haven't talked about anything. That's why I'm kind of going through all and giving you guys some research breakthroughs, giving you guys a little update, giving you guys a little spice. We're making this this video here. Actually, now I think about it, this video we're doing right now with this fucking complaint is basically like the ultimate 3.0 teaser. because I'm enjoying the energy. I like the beginning with the song. I'm enjoying these kind of side notes, kind of veering off on these kind of semi-long tangents and stuff, which I know some people are not a big fan of. But overall, I think it's the energy I want to bring to 3.0. So fuck you. Okay, it is free. You can go fuck yourself. So, but again, I'm going to go back to this. It's huge, bro. This is huge, 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 huge. Because all you need to look for is the unconditional aspect. Everything else is defaulted. Is this thing unconditional? And if you want to really go to the nth degree and you want to ask yourself, is this thing conditional? You go to your state's version of UCC 3- fuck my bleach 106, and this is talking about unconditional versus conditional. An express condition to payment, that a promise or order is subject to or governed by another record. If you don't know what that means, type it into AI. It actually gave me a really good example of it. I can't remember what it said, but it was pretty cool. I just don't. If I see something that I've never even seen this before, if I have that kind of a reaction to it, I typically don't put too much effort into it. It's like I'm not going to put a bunch of effort into trying to understand this. I've never, ever seen this ever on any instrument ever in my life. So if at some point in time I'm, coming across some complicated banking thing and I see something like this, then, oh yeah, wait, wasn't that thing I kind of barely looked into in 3-106? And I'll go back and then I'll deep dive it, right? But I'm not just going to deep dive everything. It's not totally irrelevant. It's just I could die without ever seeing it. So I'm not going to put a lot of time and effort into it, right? Point number one is really good. An express condition to payment. That rights or obligations with respect to the promise or order are stated in another record. You're probably not going to see that. So again, really the only one is one, an express condition to payment. That's it. See how easy that is? Some examples here of when it's not made conditional, right? So anyways, I'm just showing you we're starting to simplify these things pretty dramatically, which I think is really cool, right? So anyways, all that a document or paper needs to have in order to legally classify as a negotiable instrument would be the 3 points found in CCC 3104 A1, A2, and A3. And we've already figured out A1 has a default. So if it's not there, it's still there. A2 has a default. So if it's not there, it's still there. A3 is it unconditional. So really all you could reword this. You could say all a document or a paper needs to have in order to be legally classified as a negotiable instrument would need to be unconditional in terms of it promising or ordering payment. Bingo. That's it. Everything else defaults. That's huge. I'm telling you, that's fucking, bro, that one thing I just taught you guys is literally solid multi-million-dollar fucking gold. Like, I hope you guys can fucking see it. That shit is top tier, bro. One of the biggest gold nuggets I have literally ever given you guys ever in my entire fucking platform. Like, no joke. I am not kidding. Because that shit is fucking fucked what you can do with what I just explained to you. So, hope you got it. There are no additional points needed at all, and any points that would be brought up outside of those 3 points would be dismissed as entirely irrelevant instantly. No conclusive or rebuttable presumptions can be made that anything outside of those 3 points are possible because the statutory presumptions established via 1206 automatically bars such a submission. So 1206 says that if there's any presumptions here, you have to go with these presumptions and assume they're true unless there's evidence produced making them evidentially false. So they can't out-presume my presumptions, is basically what this is saying. Okay? The The plaintiff has no duty or obligation to the exchangeability of instruments tendered. His only obligation is to ensure that the instrument tendered is legally negotiable and falls within the definition found at 3104. The definition of a security, in essence, would be any document. Now, this is like fucking top tier, ultra, like Goku Killer Instinct level fucking shit right here. Okay. Top. So check this out. The definition of a security, in essence, would be any document that shows evidence of a debt. These documents fall into two categories: notes and drafts. 3104. That's all there is. Any document showing or proving evidence of a debt has intrinsic legal value. And this value is transferable, which is the basis of how an instrument becomes negotiable. Isn't that brilliant? I just thought of this. As long as both parties agree to an unconditional promise to pay, which is a note, or unconditional order to pay, which is a draft, then the value of the instrument is established and thus negotiable. Without intrinsic value built via evidence of a debt, there is no value to transfer, thus making the instrument non-negotiable due to it being of no legal value. The drafts in Exhibit A clearly establish intrinsic value due to the fact that they unconditionally order payment, which was subsequently accepted by the plaintiff, who's the drawee, and his owner, who's the person entitled to enforce the instrument. That's like top tier, bro. Absolutely nothing in this lawsuit or in any proceedings that will occur because of this lawsuit has anything to do with money, as made abundantly clear in 3102, which says that this article has to do with negotiable instruments, not money. Anyone bringing up money during any proceeding associated with this case will be wasting the court's precious time, and the plaintiff or his owner will immediately object to such waste occurring. Here's some more top-tier shit right here. Federal Reserve notes, checks, and credit card transactions are all negotiable instrument transactions. Federal Reserve notes are unconditional promises to pay notes. Duh, it says right on the fucking instrument. Checks are both drafts and checks and fall under both Division 4 and Division 3 of the CCC, which is UCC Article 3 and UCC Article 4, but they're called divisions in the California Commercial Code. Same thing. Credit card transactions produce a brand new unconditional promise to pay, which is then converted or sold by the credit card company, presumably using the provisions of 12 U.S.C. 412, and transferred to the other party after conversion is completed. All these various types of payments all fall under Division 3, which is Article 3 in the Model Code of the CCC. The term cash typically refers to any note or draft in physical form which is endorsed in blank. Like I told you before, it's one of the terms, endorsed in blank, right? Which means payable to bearer, same thing. So I put payable to bearer there. And quote, may be negotiated by transfer of possession alone, end quote, which is described literally, that's where the quote comes from, 3205B. A Federal Reserve note by default is endorsed in blank. When the drafts in Exhibit A were negotiated back to the drawer, defendant, they were endorsed in blank and would constitute cash as they were also in physical form. Fucking badass, bro. Fucking badass. If you can't explain this shit, you probably can't win in a lawsuit, because if you can't explain it, then how, you got to be able to explain it, right? Cause of action 1. I used AI to figure out I didn't use a lot of AI in anything else, but I used AI to try to figure out how to because breach of contract, they get into all this weird gay shit every single time I bring that up. So I was like, I'm not going to use that. It's gay. They just like to be bar cards and do the bar card shuffle and fuck themselves with a cucumber every goddamn time. They have to get out the fucking Diddy oil with the GHB in it and fucking lube up the goddamn biggest fucking pickled cucumber they can find and jam that son of a bitch straight up their fucking retarded fucking ass. And it's just pathetic and it pisses me off. So I'm trying to figure out, is there like another... So I told AI, I use Super Grok, the paid version of Grok, because it's the only thing that ever worked for me, and I just don't really want to learn a lot about AI. So if I can't retard my way around it, I just don't care. And Grok was very retard friendly, so I kept using it, and I've been using it ever since. I don't really want to use anything that's not retard friendly, okay? And I found a lot of cases and stuff that I was looking for through Grok that I couldn't find anywhere else. So I'm basically a Grok fan, which I know I've never really heard of anyone else who is. People always talk about all these other ones and Perplexity and ChatGPT and all this, but I've never liked any of those. I used Grok one time, but the first time I ever used Grok, I literally said, what was the case where legal fictions became persons under the 14th Amendment? And I was like, this piece of shit's not gonna give me this. And it was bang, it gave it to me, bro. Literally, it gave me the exact case and then the exact quote in the case, which you see in my treatise and you see everywhere now. And I went, holy shit. Well, at first I was like, yeah, fuck you. I was like, all right, Google Scholar, pull up the case, start reading it, and dude, I almost died. I fell out of my chair. It was crazy. So I was a fan of Grok ever since. And it just does me good. It just, the way I'm very like detailed and the way I think is the way I type the question. And it'll be like, I've been trying to find this thing and I've been searching quite a lot and I've been unable to find a definition for this. I found this definition and this definition, but I'm looking for something more along these lines and maybe something in the USU, and I'll talk like that, and it just works really well with me. So I like Grok. Anyways. So, but I don't use AI a whole lot. I use it to find a few things here and there, but I try to stay away from it as much as possible. I don't want to get too reliant on it. I look at it as like a drug or alcohol. It's like, too much of it is dangerous, I think. But, what do I know? I'm just one stupid fuck. You know what I'm saying, nigga? So if you go to the California, what is CCP? That's California Civil Procedure. 1060. There's this thing called declaratory relief. You can look it up if you want to look at it. And Grok was like, you could use this one, or you could use breach of contract. And I'm like, which one would you use? And it was like, I'd use this one. And I was like, why? And then I went and read the California Civil Procedure 1060. And I was like, yeah, you know what? I like that one. That sounds good. So that's how I found that, right? Plaintiff incorporates by reference all the above points of this complaint as though fully stated with the same force and effect as if the same were set forth at length herein. The defendant has a duty to follow the CKC in accordance with all payments, as all acceptable payments would fall into the classification of a negotiable instrument. The defendant has never demanded gold and silver money and would not be legally allowed to in accordance with 31 U.S.C. 5103, which states foreign gold and silver coins are not legal tender for debts. So many people who have gotten just their ass absolutely whooped in the courts have talked about how, money is only gold and silver and you can only use gold and silver coins. Bro, and then they lose like one case. They never go to appeals and they just cry the rest of their life like little bitches. That's the one thing they can't use, bro. What the fuck? That's the one thing they can't use. They can't use it. So, people always tell me, I've seen cases of people, they go off and they try to do silver coins and gold coins and all that. and they don't win. This is all bullshit. They don't win. It's like that's because that's the one thing they can't use. It's not legal tender. The defendant breached this duty by failing to apply or dishonor the instruments tendered in Exhibit A. While the plaintiff understands that the CCC can be complex, he and his owner have extended themselves for every possible contact. The owner has offered in-person meetings in previous meet and confers that were done on the federal case, which were denied. All extensions of contact have been offered to the defendant to explain or clarify aspects of these claims. Text, in-person, calls, fax, emails, etc. And these extensions will continue until a settlement can be reached. This should be evidence of good faith on behalf of the plaintiff and his owner. All hearings and various requests for clarifications and explanations will be accepted by the plaintiff and his owner, but this most honorable court should also be willing to step in and announce when enough is enough, and when the axiom of ignorance of the law is not an excuse becomes operative in the situation. The idea that ignorance of the law could be a defense is embarrassing and offensive and disgusting. I didn't want to go harder on that, but it's literally faggot shit. You are a fucking faggot. Literally. If anyone's watching this from City of Glendale or anybody else watching this who may be getting sued by me or by somebody else, acting or fucking what's his face from the Amex case, the guy, Stephen Newman is watching this, fuck you. Literally fuck you. Like, you guys act like retards. Like, even if you win, you're literally like, I'm going to put you on blast as like, you're literally acting like a retard. Like, even if you win, like, why would you, like, you're like selling your soul. Oh, I'll just act like a retard so I can win. Dude, like anyone can look up that case, or like, I'm going to blow all this shit up and like make it all super public. Like, you look like you're fucking retarded. You look like an infant or person of unsound mind. You know what you need? You know what you need if you're using ignorance of the law as a defense? You need an attorney at law. That's what you fucking need. Because you're literally a fucking child, okay? It's fucking pathetic. Fuck you. It's literally disgusting, okay? The defendant never attempted to reach out to the plaintiff or his owner throughout the entire chain of communication found in Exhibit A. There was also never any attempt at dishonor of the instruments tendered, which is true. I never got any phone call. I mean, look, I'll tell you right now. If I get a phone call, a text, a fax, which I literally have a fax on my phone. If I got, hey, I want to talk, or let's talk, or they leave me a voicemail, dude, I would be like down to like go to the office. I would go to the City of Glendale office and let them take a physical recorder and place it on the table and hit record. I mean, I would also want to record just because, it's just better. If they're going to record, I'd like to record. It's always better. But I have no problem with that. No problem with that at all whatsoever. So a lot of you guys, and I kind of did this too for a while when I first started doing all this stuff. It's like you don't want to talk. You don't want to get on the phone. You don't want to meet these people. Big problem. Big mistake. One of the things that Joey does all the time, he does Rule 408 letters, which is like settlement letters that they can't use against you in the case. So it's like private settlement letters that are like protected, so that you can't. And him and Sonny and all these guys, they're winning by doing these 408 settlement letters. I'm definitely going to be this. This is probably going to be the first case where you're going to see me using those, right? Because I'm willing to talk. I'm willing to meet in person, whatever. So I think it's a big part of what's called good faith, being willing to meet and talk and have communication and not just emails and horse shit. In person, ideally. Even during meet and confers and stuff like that, in this district, it says, preferably in person, I think is the exact wording on the meet and confer. But because they have the word preferably, the bar card's considered optional. So, which makes me sad because I would actually prefer in person. Like, I don't like all this Skype fucking Zoom horse shit. Call me old fashioned. I'm going to dress up in a suit and I'm fucking going down to the goddamn courtroom for every goddamn hearing. Okay. Same thing with the meet and confers. I'd prefer to meet in person, but I also have a pretty chill life and, I've got time and stuff. And it's like, I just research the law all day long and smoke cigars and fucking just, play video games and just be a fucking, generalized retard. So it's, that could be part of it too. Anyways, since there was no attempts to dishonor and the tendered drafts were in fact received by the defendant, which you'll see, I have all the certified mail receipts, which that proves that it was received, right? The provisions of CCC 3603B activate, which is the crux of the entire lawsuit. This lawsuit is a prayer to compel the application of previous payments and to ensure future payments occur without additional litigation or difficulty. The damages are clear. Power to the apartment was turned off on January 13, 2026 at around 10 a.m. and remained off until January 13, 2026 at around 5 p.m. This is harmful to the plaintiff due to an inability to perform commercial activity from the apartment, as well as various difficulties and hindrances to the owner. An entire workday was destroyed, and the quality of life for the owner of the plaintiff was markedly reduced illegally. When the owner of the plaintiff, now this is where things get interesting, very interesting. You guys are going to like this. When the owner of the plaintiff went in person to pay to have the power turned back on, he handed the payment teller one of the final disconnect notices that had been sent to the plaintiff. After the credit card payment was complete, she stapled the receipt to the top portion of the final disconnect notice, but tore off the bottom portion and stamped something on it and placed it in a pile to the side. Brandon Joe Williams asked her why she took that off, and she asked if he would like it back, to which he responded, "Yes, please." The teller proceeded to draw a squiggly line across the stamp that had been placed on the back, which can be seen in Exhibit B. Discovery will be needed to investigate what occurs with these detached portions of the original drafts, as well as to inspect each portion of what was stamped on the back. For the ease of this court, here is the exact text typed in typed form. And you can see that, which really shocked the fuck out of me. Right here, all the way down in Exhibit B. Here is the front of the coupon on the bottom. Coupon, I don't really even know if it's a coupon or not. It may or may not be a coupon, whatever this is. Here's the front side, and then on the back side of the may or may not be a coupon, we have this this stamp. She stamped it and she put it in a pile. And then when she gave it back to me, she did this squiggly, and then she put her initials. Receipt, operator, customer, amount, batch ID. Batch ID? What the fuck is this? So it's interesting. We're definitely going to be digging into that in Discovery. What the hell is a batch ID? I'm going to need to match up these customer numbers. And if it's, I haven't done the work on this. Like what, like operator, like, is that the person who was operating the computer? Is that like a login? Like who's the operator? Receipt? What's that based off of? Receipt, of what? Why is this even needed? Like you guys have a credit card processing. Isn't that the receipt? Why do you need this receipt and the other receipt? You see? Customer number, I got to double check and make sure that's the same. Also, on my credit card, it normally when I pay for City of Glendale, it just says City of Glendale. When I paid this payment, it says City of Glendale Collections. That's also going to be part of Discovery. So wait, is there like a collections company? Is it separate? Does it have the same EIN number? Who owns it? See that? Going to get very, very spicy. It's going to get very, very spicy. We'll see. So, cause of action 2, this is going to, I don't even know if anyone's going to freak out about this. I don't even think so much retardation. This is the very, 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 very first time anyone has ever seen me use any sort of tool of equity. And people are going to go, oh, man, look at Brandon, Mr. Anti-Equity. Mr. Anti-Equity. He's finally using equity, and they're going to freak out, and they're going to say, hey, how's that equity going for you? Hey, listen here, faggot. This thing, this whole injunction, you could just get rid of it. Honestly. Like, yeah, I'm using it. Yeah, it's great. I'm happy to have it. Yes, it is a tool of equity. It's not that fucking important. It has some importance to ensure that while we're doing the law, the lights don't get turned off again. So I know people are going to be super weird and whatever about it, and they're going to say stupid shit. The real truth of the matter is it's not that fucking important. And it has nothing to do with exclusive equity or any other horrific cocksuckery that's going to drive me into madness. It's got nothing to do with any of that. It's just, hey, while we're doing this, it would suck to have my power turned off again. I'd rather not. That's all this is. That's all it is. It's not magic. It's not exclusive equity. It's not magic carpet rides. It's not all the horse shit that people think it is. It's a supplementary tool that is being used. Okay? And notice I never say equity one time anywhere on this. You don't. It's irrelevant. It's an equity tool, but you don't even say equity anywhere. You just say I need an injunction. Can you give me an injunction? That's it, right? Some stuff here. These are the California civil procedure. This is the procedural part of it right here, right? I just typed into AI. Hey, I'm in California Superior Court, State Court, and I need to know what area of the Code of Civil Procedure talks about injunctions. Oh, 526. Okay, thanks. I go off and read Section 526, and then based all of this based off of what I read in 526. And then AI also gave me a few like pointers, which I took into consideration. Okay? Again, people rely too much on AI, in my opinion. But yeah, so anyways. So plaintiff incorporates by reference all the above as though fully stated, blah, blah, blah. Due to the strong burden of evidence placed on the defendant found in the presumptions that we talked about earlier, the likelihood of success on the merits is practically guaranteed. When it comes to negotiable instruments and securities, the main piece of 3104 that is presumed to be missing is a signature, but that is only because very few people are aware of the definition of that word is much more broad than people presume. And it can be shocking when people see CCC 1201 B37 for themselves. With this piece in full cognizance of the court, the presumptions above solidify themselves unless somehow rebutted with evidence, which simply seems like an impossible feat, because it does. It's like never going to happen. Due to the fact that the plaintiff and his owner have been performing on each bill for months to full satisfaction of all claims, there is absolutely no harm done to the defendant by having an injunction in place that prevents them from turning off the power until we conclude this lawsuit. The plaintiff and his owner will also continue to perform on each new draft issued during this time period. And then AI was like, oh, you need to talk about like irreparable harm and like, oh man, and all this stuff. And I'm like, bro, I'm not going to like play the victim card. Like, I'm not going to sit here and talk about how, oh, I'm going to be so hurt and all this. These fucking pussies can't hurt me, bro. Fuck these faggot pieces of shit. I'm just not going to do it. I'm just not going to like stoop to that level, right? So it's like, it would be difficult to state that turning off the power would cause great or irreparable harm to the plaintiff and his owner. But it would most certainly create waste and additional damages that are simply unnecessary and can be avoided. Plaintiff will not attempt a song and dance to amplify what could occur. There is no situation, as of the writing of this complaint, that would cause the plaintiff's owner some massive health issue, but it would cause damages commercially for the plaintiff and would lower the quality of life dramatically for the plaintiff's owner. I'm just not doing it. I don't give a fuck. If you don't want to approve this because I'm not talking about sucking dick in some alleyway because I became a drug addict because he turned off my electric, then just turn the fucking thing off. I don't care. I'd rather have no electricity than be a fucking bitch. Okay? Fuck you. That's the truth. That's just where I'm at. Okay, guys? Turn my power off. I don't, it's fine. Like, I'd rather have that than literally like suck someone's cock. Sorry. Just not going to happen. So, here's where we start getting into background supporting case law. All this case law comes from the vapor money theory. For those of you who have seen my vapor money theory resources and documents over at the Amnesty Coalition, you're going to go all the way down to presumptive rebuttal definition for term vapor money theory. This is where all this case law comes from. I just copied it and pasted it and transferred it over. Great case law, by the way. Phenomenal case law, right? So, and I actually used this entire rebuttal in my reply brief on the MX appeal. So if you go up to the K7 appeals on MX, and you're going to go all the way down to the bottom, you're going to see this reply brief. So the way that an appeal works in federal court, maybe also in state, I don't know, we may find out here in a minute with this case. The first thing is the opening brief, which is what the person files who got the case into appeals. Then you have the answering brief, which is and I'll show it to you guys. You have the opening brief. Then you have they did a motion to dismiss and all this other horse shit, which I actually won that, which is the only motion I've ever actually won. In all my years of doing this, I've only won one motion ever, which is always really, really sad and depressing, but it's just this one. It's the only one I've ever won in my life. So there you go. It's a special one, special motion. And then they were forced to file in the answering brief. Here's the answering brief. And then they call it an optional reply brief. So the optional reply brief is sort of like a reply to the answering brief, right? They use sovereign citizen and vapor money theory in the answering brief. So I used the overarching general rebuttals. I used the presumptive definition of the term sovereign citizen under Rule of Evidence 301. And then I use the presumptive definition of vapor money theory under Rule of Evidence 301. So I use both of them. And that's when I developed those. I think the timelines are the same. That's when I actually developed these and put them on the website. 8/11, 8/3, 7/31. Yeah, so right around the same time period, I think, I filed this 8/10. Yeah, so I was developing, so when I was writing this reply brief is when I developed those and put them on the Amnesty Coalition. So there you go. That's all those quotes. Demand for relief, wherefore plaintiff respectfully requests that this court enter judgment in his favor and against the defendant as follows. Preliminary injunction, equity, for all you cocksuckers out there. Refund of all overpayments in the form of Federal Reserve notes that have been tendered on the accounts back to the date of the first communication of the federal case, which would be January 23rd, 24. $35,001 in additional negotiable instruments called Federal Reserve notes or any other legal tender under CCC 3104 and 3311 to cover the annoyance and damages associated with all phone calls, litigation, missed work due to no power, shower in the dark for the owner, having to physically go to the building despite having the obligations already satisfied. So you got to ask yourself, why $35,001? I've got a good answer for you. So if you look at the civil cover sheet, we're on page 19. You will see, let's see here. Civil case cover sheet, unlimited amount demanded exceeds $35,000. Limited amount demanded is $35,000 or less. So I went to Grok and I said, what is this limited versus unlimited thing? And it was like telling me some stuff, and then I kind of noticed something. I was like, wait, is there different, like, if I wanted to go to appeals in a limited case versus if I wanted to go to appeals in an unlimited case, tell me the differences as to how those two appeals would go. And it's like, oh, a limited case would go to like an internal appeals court within the Superior Court of Los Angeles. An unlimited case goes to an entirely separate court, which is the Court of Appeals, the actual appeals court. And I was like, so you're telling me if I do a limited case, I can't even get into the Court of Appeals? He's like, well, you can, but under only really specific situations. And I was like, okay, is there a way to do a limited case, go to the appeals court in the Superior Court, and then also go to the Court of Appeals, and then still be able to go to the Supreme Court? And it was like, no, it's really not going to work that way. Unlimited is really the only way you're going to get to the Supreme Court. And so the way I looked at unlimited versus limited was limited was basically like a clever way to get people to waive their right to appeal. That's the way I like looked at it. Like, maybe that's not right. Maybe I'm missing information or whatever, but that's just the way I took it. I took it as like a fuck you a little bit, right? So I said, oh no, I'm not waiving my right to go all the way to the Supreme Court. This is a beautiful case. This has every single element that I've been missing in all of my other piles of shit that I filed. This case, if I have to take this case all the way to the Supreme Court. So I made it for $35,001. And to me, that's basically telling the court, like the way I look at that is it's me telling the court that I am not waiving my right to an appeal, and I'm not waiving my right to go to the Supreme Court. That's the way I look at it, right? So anyways, that's why it's like that. And then finally, either a permanent injunction forcing the defendant to accept and process the plaintiff's payments each month in accordance with the CCC, or some kind of promise to perform from the defendant that they will follow the CCC. Ideally, a power of attorney established that allows the defendant to endorse instruments on behalf of the plaintiff would actually be the best relief possible. In this way, there will never be a possibility of this occurring ever again in the future, and so that the defendant may always have instant and guaranteed performance on all tender drafts. If the defendant is willing to accept the power of attorney option, the plaintiff is willing to speak about lowering the damages requested, mentioned previously in the complaint in an attempt to show good faith, as this option will require much less work on behalf of the plaintiff as well as the defendant. This option is the option where everyone wins with the least amount of work or effort from either plaintiff or defendant. Any other damages that will be found via the discovery process. What exactly happens with Exhibit A and Exhibit B in terms of negotiability, swapping, sales, transfer, collateralization, and any interest-bearing aspects will incur additional damages that will need compensation for relief and possible additional injunctions or agreements to manage how these instruments are treated, especially since the owner of the plaintiff has a federally registered trademark on the name of the drawee on the instruments found in the lawsuit. Any other relief that this court may consider equitable for this case. Signed, owner. Pretty dope, in my opinion. Here's the letters. You guys can actually see the exact letters that I sent. Enclosed is one endorsed original draft that is being tendered in good faith for full satisfaction. Remember earlier, 3311B says that there has to be conspicuous attached letter saying that it's in full satisfaction. That's it. Full satisfaction of the original claims. This in accordance with 3311. And then talking about the small claims case and talking about this, and then here's the stamp on the instrument, right? You guys can pull this up and read this, and then here's the actual bill. You can see the stamp. It's a red stamp, and then I sign with a blue pen for no fucking reason. By the way, I know there's not very many of them left. Thank God they're a dying breed, but we have this whole like, red is for the land and stuff, people, which I kind of. That's like way back Anna Von Reitz type shit. Maybe David Straight type shit. It's all horse shit, by the way. Complete horse shit. Red means nothing. Blue means nothing. The reason why I use red and blue is just to make it really noticeable. That's it. I'm telling you guys. That's the only reason why. I use red to make it like, holy fuck, there's a gigantic endorsement here, and so people can see it. And then I use blue to sign because I want it to be very noticeable that it's a hand signature, and it's easier to see that in blue than it is in black. Black could be like, is this a stamp? I don't know. That's the only reason why I do it. That's it. There's no other reason. Got, more of the bills. You guys can see how much power I consume. So gay. Here's the proof that it was picked up from the website there. They sent me a friendly reminder that I didn't pay when I did pay. So I responded to their friendly reminder. I previously submitted a payment in full by endorsing the original draft of the blank qualified endorsement, then tendering that negotiable instrument back to you with a cover letter explaining the situation, which acts essentially as a launch. This was picked up by an individual at the Glendale post office on August blah, blah, at blah, blah, blah. The numbers blah, blah, blah. In your enclosed letter here, you have not mentioned any aspect of dishonor as regards to the original tender draft. For your convenience, I will place the rules of dishonor for an accepted draft here from the California Commercial Code in bold for you to review. The draft is considered accepted once it was endorsed. And then here's the exact in bold, right? I can only presume, due to the fact that you have received the parcel and not disordered the draft, that you are, quote, refusing, end quote, the draft in accordance with the California Commercial Code 3603B, which I will place here in bold for your convenience. I have already filed 2 lawsuits, one which was dismissed in federal court due to lack of diversity jurisdiction or federal question jurisdiction, which was all correctly dismissed, and I had a misunderstanding on how those 2 jurisdictions worked. The other suit was a small claims case which was dismissed for lack of damages. At this point, we are in a standstill because I am unable to file more litigation without concrete damages, for example, shutting off the power to the domicile. At this point, this will be my last letter as regard to the situation. If you are ignoring my communications on the subject, then we will simply let the situation move forward naturally into the power being shut off. Then I will have the damages needed to file in the next suit, which is obviously what this is, right? I don't see the point in continuing to communicate if it will simply be ignored and it costs currency to send each letter certified mail. I would like to be abundantly clear that the cycle of receiving a draft from you, endorsing and tender it back to satisfy the obligation, having the power turned off, and then suing will be a never-ending cycle until we can speak about the situation. I am available for a phone call from your legal team or anyone else at, there's a number, call. I am available for calls, and I am entirely consenting to any calls to be recorded, just in case that is something that is desired for legal purposes. I would even be willing to meet in person for a lunch, physically come to your offices for a meeting or anything else to discuss the matter, and reach an amicable resolution without resorting to an endless cycle of litigation. Thank you very much for your time. I will be more than happy to respond to any direct and relevant communications written to me as regards to the above information, but any automated messages or letters not pertaining to any of the above information will be ignored after this point. If there is no desire to speak on the above matters, then we will wait to speak on these matters once more litigation commences. And that was the last time I ever sent them anything. Everything else after that was just me just performing on the negotiable instruments, right? So you'll just see here's another bill. Wait, what was that? Oh, that's the friendly reminder. That's the friendly reminder letter. And then we have another draft here that was tendered. Very, very simple. This is when things became much more simple. My mind became so much more clear. It was just became kind of one-pagers after that. Thank you very much for the enclosed draft. You'll see they added the previous months as unpaid. So I just crossed all that out and wrote physically with a pen the correct number of just the 1 month and just crossed out all the old stuff that they said I didn't pay. Thank you very much for the enclosed draft. Due to an incorrect amount on the draft, I have handled and accepted it in accordance with the California Commercial Code 3114, which I will place here in bold for your convenience. If an instrument contains contradictory terms, type written terms prevail over printed terms, handwritten terms prevail over both, and words prevail over numbers. I have removed the incorrect amount that was duly tendered previously and have made the value of this unconditional order to pay only including the recent months of use. This fixes the draft. The draft was then accepted with a qualified and blank endorsement and tendered back to you for accord and satisfaction by use of an instrument under 3311. And then here's that 3311B. You have the attached obvious communication saying that the obligation is satisfied. This is the point right here, the 3311B. This obligation is now satisfied in full. More drafts. You guys can kind of see the drafts. You guys can see how I attach things here. This is an exact duplicate of the last one. Just the exact thing, same thing again. And you just see the exact same thing, crossing out all the incorrect amounts and just placing the correct amount at the bottom too with pen, according to 1114, right? And that's it, guys. Exhibit B is the maybe coupon, maybe not. I don't know what it is at the bottom that was stamped. So there you go. I hope you love this one. This is top tier gold. There's a few of those points in there that are just so top tier. So hope you guys like this one. I haven't done a long video like this in a long time. So let me know what you think. Let me know what you guys think about this. This week I'm going to file this for service of process. It'll probably get served Monday, and then I believe I have to research it again. I'm going to deep dive now. I'm going to go into ultra discovery mode now for the next 10, 12 days. I believe 10 days after they receive the complaint from the process server, I can serve discovery requests. Don't quote me on that one. This is all new. Discovery is all new to me. But I'm very excited to get started, and that is sort of like the next phase of this you're going to see me doing. And I will be kind of slowly writing the outline for 3.0 at the same time. I'm kind of going kind of slow with it. So people ask me when 3.0 is coming. I don't know. No idea. But it's a slow train. It's not we'll get there. This year for sure, probably before the summer, maybe by the summer, something like that. Anyways, okay, guys, hope you guys love this. It's a very, very cool video, very fun video. I like the energy a lot more than what I've had for quite some time. I think it's a better energy, bringing that kind of 1.0 energy back, minus the horrific, brain dead informational aspect of 1.0. Bringing the energy of 1.0 with the information of 2.0 and then enhanced to 3.0 is going to be the ultimate combination. So glad you guys are here, and I will talk to you later. Bye-bye.